The third thing we're going to talk about is advanced care planning in general. What is it when we're talking about advanced planning or advanced care planning? Put quite simply, it's the organization, the thought, the planning that we do now, while we are still capable of doing so, around what you would want in the future if you could not make that decision for yourself. As an adult, in any part of the country in Canada, you have the right to make your own decisions. If and when you are no longer able to give consent, it's very important for us to plan ahead, to choose somebody or to express wishes so that somebody else can make the best possible decisions, the ones that you would want them to make. We often think that other people will simply just know what we want. Family members and friends, we just think, well, they'll sort it out. They know who I am. So how we do that planning is critical now. As we're looking at this chart, you'll see 4 squares. And this is what we call the Nexus of Capacity. Let me explain it to you this way. In the section that says capable, that's you as an adult who is able to make your own decisions. You have the function to do it. You can understand and appreciate the decision that's being asked of you. You understand the implications of that decision. And then below, you're the person to make that decision. On the other side is a person who may be completely in a coma. We'll put it in the farthest possible reach. So they are completely incapable. They cannot communicate in any way, and they need somebody else to decide. We often call a substitute decision maker. So that north-south line is, if you will imagine, you're crossing the street. And on one side of the street, you're perfectly fine, absolutely capable of understanding what's going around you. You get hit by the bus, and you're perfectly incapable. You're in a coma. And that's what those 2 sides would be. Now, we know that can happen, but it's usually not what actually does happen to people. Usually there's a gray zone, and that gray zone is one that people who work in the areas of dementia or other forms of intoxication, cognitive impairment, or mental health are often wrestling with. Look at the east-west line. That's what we call the, if you will, capacity or incapacity nexus. So if you as an adult have ever had a couple of drinks, a couple of alcoholic drinks, you may have been perfectly capable before you had those drinks, and maybe 1 too many drinks along, you become less capable. But we always talk about capable of doing what? We're talking about making different kinds of decisions. All right, in the example of 1 too many drinks, you become incapable of driving legally pretty quickly. You may become incapable of walking in a straight line at an earlier or later stage. You may be incapable of doing higher level mathematics farther along the line. It depends. We know that people with dementia, as an example, may have better times of day than others. It may be that they're good in the morning and not as good in the afternoon or in the evening. People who may have blood sugar issues may be better after they've had a chance to have good hydration and a good meal. So when we're talking about capacity, it's really important to understand we're not just talking about one thing, one fixed idea. A person is or isn't, a bipolar type of notion. It's not that. It's not even binary. It's in a gradation. So how does this apply to advanced care planning and dental elder abuse at all? Well, when you're doing your planning now, you're in that capable category in the top side. And you need to find somebody or a way in which to communicate what you would want, your values, wishes, and beliefs, to somebody who'd be making the decision for you. In Ontario, as in most jurisdictions in the country, but not all, there is a default substitute decision-making list. So what happens if you haven't made some type of a power of attorney document? In some jurisdictions like British Columbia or the Yukon, they may call it a representation agreement, but it's the same kind of legal document that allows you to pick a person now, while you are capable of doing so, who will be your substitute decision maker later. In the province of Ontario, that person's called a power of attorney for personal care. It's important that we take a minute here to note the difference between a power of attorney for personal care, who makes health and personal care decisions for you, and the other kind of power of attorney, which is what we call in Ontario a power of attorney for property, and in other jurisdictions, similar things. Power of attorney for property gets to make your financial decisions. Sure, they can be the same person. You can pick the same person or even the same two people to make those decisions for you. But there may be good reason that you choose different people. You may have the son that's good at health and personal care decisions. You may have the daughter who's an accountant or a very good person with details in finance, and you may choose those people separately. So it's up to you. But I'm going to be talking about a power of attorney for personal care right now. If you do not pick a power of attorney for personal care in the province of Ontario, as I said, like so many other jurisdictions in the country, there is a default list. So there will always be somebody to make a decision for you. And the list you see in front of you now is the default list for healthcare decisions in the province of Ontario. The top one says a court-ordered guardian. Okay, this is actually quite rare, in fact. But unsurprisingly, somebody who's been appointed by the court to be the decision maker has the top ranking. The second one, the much more common one, is somebody that you, as a capable adult, have appointed to be your power of attorney while you were able to do so. And that's kind of what we've been talking about. If none of those things happen, then who gets to choose? Well, in this province, we also have something called a consent and capacity board. Now that's unique to Ontario. So if you're in a different jurisdiction listening to this, that won't apply to you. So this little tribunal, very effective, very able to make decisions around these things quite quickly. If someone's appointed by them, then it's them. Okay, so those are the top three. A court, somebody that you've appointed pursuant to a power of attorney, or in Ontario only, somebody appointed by the Consent and Capacity Board. Well, those are kind of arcane. But what about for regular people? What's the default list for them? Well, it kind of follows what you would imagine it would be. First substitute decision maker in your default list is going to be your spouse. Same sex or common law or married is fine. It's all the same. It's your spouse. If you do not have a spouse or they're not available, it will drop down to your children. And again, there's no ranking in terms of age, no matter what the eldest one might say. All the children are ranked equally. Also, no gender preference. If not your children, or your children are not of the age of majority, they have to be adult children, it goes to your parents, again, ranked equally. If not your parents, then it goes to an incapable person's parent who only has right of access. Now that's a bit of an interesting, different one. That's really only for cases where you may have some type of custodial order or so on. It happens less commonly. Then it goes down to brothers or sisters. So if you as the incapable person have brothers and sisters, it will go to them equally. And if not, then any other relative. And if not, then it will go to the public guardian and trustee, which is part of our social safety net. And they themselves will try to find somebody who knows you well to make your decision, or if not, they will make the decision themselves based on the information that they have. So that is the ranking list that we have, but that's only for health and personal care decisions. Here's what most people don't realize. There's no default list for financial. So if you have not made a power of attorney for property in Ontario, or a power of attorney that deals with your financial matters, no matter what it's called in another jurisdiction, there's no default list. So it's not going to go to your spouse, or it's not going to go to your kids, or your parents, or any of those other things. It's going to go directly to the bottom. It's going to go directly to the public guardian and trustee. So really, really important to be thinking about making powers of attorney for property, because there's not going to be any default list. So why are we talking about this in terms of dental care? We're talking about health care, that makes sense. Decisions around somebody's mouth is an oral health care decision. But in Canada, in particular in Ontario, so much of dental care is private pay. And there may be insurance questions also associated with them, which really means if you are a person who becomes incapable of making your own health or financial decisions, you're really going to need both someone to take care of the decisions around the treatment, as well as the decisions around how the dentist will get paid. It's an important part of advanced planning around dental issues. And one of the reasons many people do not get the dental care they need is because people who are trying to support them are not able to access the information about how to make decisions. And in some cases, people are being exploited. And the money that otherwise would be spent on health and oral care is not being spent. That can be a recipe for abuse and neglect. So you see here on this particular note in front of you, the who gets to decide. That's a quick version. Again, court-ordered, person who's a power of attorney, somebody who's appointed by the Consent Capacity Board, and really, you'll see for financial decisions, it's only the public guardian and trustee. That's all you have. There's no default list.